we were before Justice over the same matter. And before the High Court, Your Honor, we have challenged some of the averments contained in the affidavit, the constitutionality of the process, Your Honor. And all that the ODPP has made an application to be granted more time to investigate, my Lord, Your Honor. I'm just wondering where that is premised on. Whether you need to sustain an application such as this one for them to investigate, or whether there's any anything inhibiting their investigation. The most important point, Your Honor, that I want to point out is the inventory. The inventory forming the subject of these investigations. And you've had the IO. Yes?
It's not in that file.
It's not in the file. But Your Honor, you on one thing. Yes, only one thing, Your Honor, if you may allow me, you may decide whether or not it is legally relevant. The most important thing the IO has indicated to you is that they are investigating forensically the confiscated gadgets. Those gadgets, Your Honor, the IO is investigating are the ones contained in this inventory. So by way of backdoor, they have introduced this inventory. Why it is not before you, Your Honor, is because they want to conceal the manner in which these gadgets were confiscated. The propriety of the confiscation. All what I wanted to point out to you, Your Honor, is that these gadgets were confiscated in the absence of, or in breach of the procedure contemplated by Cap 75 and in the absence of a search warrant. Yes, Your Honor? But Your Honor, how about that aspect that they're investigating gadgets that they corrected? Or could he indicate the gadgets that they're investigating? Yes. Yes. No, it isn't. No, it's, but with an application for you to extend orders for investigations based on gadgets that were unlawfully procured. How do we deal with that conundrum? Because it is you now who has a jurisdiction to say, go on with the investigation. If you order so, they will be investigating these gadgets that were unlawfully procured. How do we resolve that conundrum? Because it's you with the jurisdiction.
What has the High Court done?
The High Court has just given us a date for Thursday for a ruling.
Because I believe that is before the High Court.
Yeah, but then it's not before the High Court. It's before you, Honor, because the gadgets were subject for investigations. Your Honor, are the gadgets subject of the investigations not before you? Because he has made reference to gadgets.
But part of the when I gave the orders that they investigate within 3 days, that
Yes.
included all that.
But Your Honor, this a legal issue I'm pointing out. And the legal issue is that the gadgets that you are just about to extend the orders for investigations were unlawfully procured. They deliberately refused to give you the inventory. They never annexed it. Even the manifest itself was never annexed to see whether Mr. William Ruto was on board that flight or not. That's the legal propriety I'm indicating to you, my Lord, Your Honor. The conundrum for you to resolve within your jurisdiction.
I believe that since you went before the High Court, this court is not seized.
My lady, if I may.
Already pronounced itself. It has released the suspect. All those issues are within the High Court.
My lord, my lady, let me.
Yes, I think for me now my hands are
No.
in fact as official.
My lady, I don't believe that your hands are tied on this
They are not
particular
tied,
matter.
but I'm done.
I don't believe so, and this is why I want to. I'm on my feet. The application before the High Court, I'm the advocate who drafted that particular application. The issues that I raised in the High Court were on the issues as far as how the custodial orders were obtained. My lady, what is before you is an issue as in reference to a search warrant which has been granted. And ideally, when the arrested person was presented before you, on the initial miscellaneous application in 2922, my lady, there was no iota of evidence that was attached on that miscellaneous application. None whatsoever. And because the fact...
Maybe that one was done, it was spent.
My lady, then...
I had it and I gave 3 days.
My lady...
I sold 7 days, I gave 2. A 3 are over.
Then, my lady...
But you are not happy with the 3, you moved to the other.
We did move to the High Court because there was the court in itself which granted the orders was actually misleaded to actually granting those particular orders.
Okay, then we can do this. If that's the position the court takes, what is the fate of the matter before you? Do you have a live case or not? So that then we close this matter, we close this file.
This file has come for closure.
All right, if that's the case, then let's proceed and have the orders.
Then in that point, he should actually be ordered to release those particular gadgets. Because he has not appeared before the High Court to address this particular inventory. As we close the file, the gadgets should...
Before the High Court, he was not involved.
He is involved. The DPP is involved.
The DPP was there.
Let her close the file. Let the court close the file.
The IA is not involved in the High Court.
You can proceed to close the file, then we shall make the subsequent orders.
You're not, if I may.
Let me hear the prosecutor.
Yes. Council is very quick to, as far as I understand the issue, the
File is this, it's closed.
Yes, that is enough.
Next file. Next file.